And being a former colony, we have English common law. Then, of course, the Constitution of the Bahamas. And those who don't have a copy of the Constitution should purchase one. They're not expensive, because every Bahamian should own one and should have read it. Then we have our Bahamian case law, which you will get familiar with. Then we have our legislation, which you can find on the government's website, Laws of the Bahamas, where we have our primary legislation and then our subsidiary legislation. So that's the acts and the regulations. But also law comes from custom, the way in which things are done in society. And that's what triggers laws to be changed based on custom and practice. And the last source of Bahamian law is equity, which means that when a judge looks at a matter, he decides what is fair and just. When he's giving his decision based on whatever the issue is before him. So the judicature of the Bahamas starts from the magistrates court, or the administration courts. We move up from that to the Supreme Court, from the Supreme Court to the Court of Appeals, and from the Court of Appeals to the Privy Council in London, which is the highest court of the land. So the Privy Council hears appeals from the Court of Appeal. The Court of Appeal hears appeals that come from the Supreme Court and the Industrial Tribunal. The Court of Appeal enforces fundamental rights and freedoms. And that's why you should read the Constitution. It also hears appeals for civil and indictable offenses. The Supreme Court hears civil matters or claims over 5,000 or more. It also hears appeals from the magistrate courts and various tribunals. Supreme Court also hears matters relating to common law or to equity, commercial matters, admiralty, family matters, probate. All of those are heard in the Supreme Court. And the Supreme Court sits in New Providence and Grand Bahama. Now, the magistrate court is really for criminal matters and indictable offenses, and where the penalty is no more than 5 years imprisonment or a fine of $10,000. It can hear civil matters, but it can't exceed $5,000. And if it has to do with property, it can't exceed $200. Now, the magistrate court can hear appeals for civil and minor criminal convictions from lay magistrates and Family Island administrators. Lay magistrates will be can be a justice of the peace, whom the chief magistrate has sworn in to be a magistrate when they're in need of more assistance. So we have magistrates in New Providence, and that includes the drug court, the firearms court, the coroner's court, the night court, and we have traffic courts, night traffic courts. We have magistrates in Grand Bahama and in Abaco, and there's a resident magistrate in Exuma and Eleuthera. Now, the Family Island Administrator's Office, that's where you have matters heard by lay magistrates, even though you can have some lay magistrates here in Nassau. If the chief magistrate feels that they need assistance, especially for the night courts. And they would hear civil matters where the amount claimed doesn't exceed $400. And they hear appeals from conviction or civil matters may be made to the magistrate's court. So when I started, I told you that being a former British colony, that we follow English common law. Even though we have our own judiciary, we have our own decided cases, we still follow English common law. And because we follow English common law, there's certain terminology that you need to be aware of, especially when you read these cases. So when you hear someone say that the judge says he's referring to the ratio, that means he is looking at the reason that the judge made for coming to his decision. And that reason is what makes the case binding. That is what you look to see whether or not you are bound by that case, which means that you must follow. So judicial precedent means that you could have a binding precedent or you can have a persuasive precedent. A binding precedent means that if a decision was made earlier than the one that the judge is presiding over, and that is a higher court, and the matters are similar or more or less the same as to what he now has to decide, then that decision is binding on him. So if the judge is in the Supreme Court and a matter was heard in the Court of Appeal, he is bound by that decision by the Court of Appeal. If the matter is in the Privy Council, he is bound because it's a higher court. Same as the Court of Appeal, they're bound by decisions made by the Privy Council. A persuasive precedent is one where the court is not bound to follow, but they can be influenced by it. So you'll see when you start to read the cases where the lawyers refer to certain cases that were heard before, or you'll see where the judge, when he's setting out his decision for coming to the conclusion, he's going to give you cases that he is relying on. Some may be binding and some may be persuasive. So a persuasive precedent can be a decision that was made by a foreign court. It could be made by another Commonwealth jurisdiction. It could be made by a lower court or even a court with equal authority, which means a Supreme Court in another jurisdiction. When you hear them say stare decisis, it means let the decision stand, which means that the court is bound to follow the binding precedent. And distinguishing is where you look at the facts to see if they are the same as the facts that you are now presenting to the court. And what you do is try to show to the court where the facts in your case is different from the facts in the case that is the binding precedent. So what you're doing is actually distinguishing your facts from the facts in the binding precedent. And let me stop there. Any questions, comments, queries?
Can you kind of elaborate just a little bit more on the when you was talking about just now with the distinguishing, you're saying you're going with your facts based on, I wasn't quite clear on the,
Okay,
you're
so
comparing.
okay, so let's say you had an employee who was dismissed. Okay, one I'm going to share with you later tonight. This one is a case where the employee said that the procedure for his job didn't meet the international standards. The company is saying that they had a procedure, but they're in the process of changing that procedure. So let's just say there was a matter in another jurisdiction or a matter by the Privy Council where the facts were similar to the same one I'm going to read to you, where there was a plane and a hang-on, they were moving the plane. And based on, so the facts are more or less the same. But in this one, the procedure may have been different, or the plane may have been bigger. Like this
Okay.
has, yeah, you distinguishing mean you're showing the court that there are, even though we're talking about the same thing, there are slight differences that is going to cause us to come to a different decision.
Mm.
Or sometimes they use different laws. They may look at what our law says and look at the law where the case was heard and say,
Mhm.
yeah, the facts may be the same, but their laws are a little bit different.
Mm.
That's what distinguishing means. Because if the facts of the case are more or less in line with the decision that was made by the Privy Council or the Court of Appeal, then you are bound to follow it.
Mm.
If you don't want to be bound to follow it, you have to show the court what are the distinguishing features of your case compared to that one.
Okay.
Yeah. Anybody else? Don't be silent now. Nobody?
Nothing at this time, no.
Okay, all right, good. So when a judge looks at a piece of legislation, he is responsible to interpret that legislation. So even though you see we have the Employment Act, if you want to know what a particular section means, yes, a lawyer can give his interpretation of what it means. But to truly know what that clause actually means, it has to go before a judge. And that's why the cases are so important, because the judges interpret what those sections mean. So a judge, when he's interpreting, he has 3 rules. There's actually 4, but I've only given you 3. The first one is the literal rule. So he looks at the statute and he says, let me give the word its literal or grammatical meaning. Now, if he finds that that literal rule interpretation would come out meaning something foolish or contrary to the intentions of Parliament, then he will use the golden rule. And depends on the legislation, he can actually interpret using the mischief rule. And so that's where the judge would then look at the legislation and seek to determine what exactly was the intention of Parliament when the legislation was passed. And the one that I don't have here, which is the 4th one, is the Justum Generis rule. And that's where the court looks at when there is a listing in the legislation. It looks at the first word, and then it looks at all of the words afterwards to see exactly what was the thought of Parliament when the legislation was written. So let's say in the legislation it said all modes of transportation with 4 wheels. And the matter before the court, let's say it's one of those tourist motorcycles on 3 wheels. Under the rules of interpretation, the legislation said 4 wheels, and then it gave you examples. So if the matter before the court only has 3 wheels, then that section of the act cannot apply. So for your notes, it's just the 3 rules: literal, golden, and mischief. Now, we said earlier that our laws come from different sources. We know it comes from custom, it comes from equity. Laws can be drafted based on the Constitution, changes in society. So how do we come about creating and drafting these laws? So you can have a statute or a regulation drafted by the legal counsel in a government ministry. Or you could have it drafted by the Attorney General's office itself. If it comes from the government ministry to the Attorney General's office, then the amendments and comments are sent back and forth and then it's finalized. It is the minister who's responsible for that particular ministry who presents that document to Parliament. Now, depending on what the issue is, there's normally a white paper and a green paper that's prepared. The green paper is a government publication, and what it does is it gives you details of an issue. And then it talks about the course of action in terms of policy and legislation. So the green paper was what was used when we went about seeking independence. The white paper is for public consultation and debate. And everybody in this class should know the white paper because one was issued for that. So once you have the draft, you have the first reading. And that's where the bill is tabled in the House of Assembly and it gets its formal reading. Then you have the second reading, and that's where the bill is debated, but no amendments are made. Now, sometimes the second reading and the committee stage go together, and sometimes they're separate. Because if a committee isn't needed, then it's just a second reading, and then you go to the report stage. And the report is where the bill is returned to Parliament, and if there are any amendments to the bill, they are debated. The third reading is where they vote on the bill, and once the bill is passed, it moves to the Senate. And I know you'd have seen a lot of comments made by the Senate when bills are sent to the Senate. So they go through the same process where it's tabled, and then it's debated, it's discussed, and if any amendments are made, it's returned to the House of Assembly. And they consider it. If not, then once the Senate is finished tabling and debating it, it goes straight to the Governor General for royal assent. And that is how a bill becomes an act. Any questions? No?
No, not now. Thank you.
This is wonderful. All right. So when you talk about employment law in the Bahamas, what drives the process when an employee is unfairly or dismissed or wrongful dismissal or constructive dismissal? The mechanism for seeking a remedy for whatever action it is to the Bahamas Industrial Tribunal. And the Industrial Tribunal is what we call a quasi-judicial process, which means it's not as rigorous as when you appear before the Supreme Court or the Court of Appeal. So it's really an administrative body established by an act of Parliament, and it deals with disputes between the government and a person, or person and person, or even a legal entity. Domestic tribunals are disciplinary committees for professional bodies which are regulated and may be established under statute. So we do have some domestic tribunals that deal with professional bodies. So the Industrial Tribunal was established to hear and determine matters of employment on an industrial nature. They have legal powers to enforce rulings and ensure that certain actions are taken or legal remedies are made. Now, this whole concept of having a tribunal came from the United Kingdom. They started industrial tribunals in the 1960s and then moved on in the 1970s to calling in employment tribunals. And they extended the jurisdiction beyond just industrial matters to include employment rights, equal pay, maternity benefits, rights of trade union membership, racial, sexual, and disability discrimination rights. So in the UK, they fall under the Employment Tribunals Act and the Employment Tribunals regulations. In the Bahamas, we have the Industrial Relations Board that was established in 1970. And the purpose of that was to hear all disputes relative to essential services referred by the Minister of Labor, to register industrial agreements, and to hear any matters relative to the registration of such agreements. Then the act was amended to establish the Arbitration Tribunal to hear all the disputes relative to non-essential services. Then the Bahamas Industrial Tribunal was established by the Industrial Relations Amendment Act 1996. And that replaced the former Industrial Relations Board. And the decision in the case of Princess Casino versus the Minister of Labor ruled that the arbitration process was voluntary and that all parties had to give consent to the process. This was not agreed to by employers, hence the government, in consultation with the unions, established the tribunal. So the Industrial Relations Act was amended in 1997, and the jurisdiction of the tribunal was stated to include hearing matters involving trade disputes for essential and non-essential services, and the recognition and registration of industrial agreements. So the tribunal has powers to order reinstatement, damages, and other remedies in the resolution of workplace conflicts and trade disputes. The tribunal matters are heard in Nassau and Freeport, and the tribunal is accessible to the public, and the service is free. Individuals commencing labor-related actions or trade disputes do not have to be represented by legal counsel. They can represent themselves at the tribunal. So the jurisdiction of the tribunal was amended in 2012 to establish that the Registrar of Trade Unions and Industrial Agreements would be responsible for the registration of industrial agreements. The Industrial Relations Rules was enacted in 2010, and that establishes the rules and the procedures of the tribunal. As a quasi-body, the proceedings of the tribunals are meant to be less costly, more expeditious, less formal than a court of law in resolving trade and labor matters. And of course, the rule relating to admissibility of evidence that apply to a court of law do not apply to the tribunal. An appeal from decision of the tribunal may be made in the Supreme Court, and a further appeal can be made to the Court of Appeal. So the composition of the Industrial Tribunal, the tribunal is comprised of 3 members appointed by the Governor General. We have the President, Indira Demerit Francis. We have the Vice President, Helen Almorales Johnson. We have another VP, Sharada Humes Ferguson. Another VP, Ingrid Cooper Brooks. And an acting VP, Rionda Delaveau Gadet. So they have security of tenure, which means that they can work up to the age of 65. It can be extended to 67. Any matter of the tribunal may sit alone. They could hear, adjudicate a matter. The matters could be heard in Nassau, Freeport, or any other place that the president may elect to hear proceedings. The Industrial Relations Act, Section 54, subsection 4, states that the president shall be the senior member of the tribunal and shall be responsible for the administration of the affairs and business of the tribunal. So overall, the president and the vice president may also be assisted in the resolution of trade disputes by a panel comprised of fit and proper persons from a trade and industry or financial services or labor unions and other areas of Bahamian society who are selected by the Director of Labor. The number of persons on the panel is 12. 6 are appointed by the Director of Labor after consultation with Employers Association, and the other 6 after consultation with employee associations. The term of office on the panel is limited to 3 years, and the Director of Labor has the power to revoke the appointment of any member that he does not deem fit to continue serving. The president has the power to select one person from the panel appointed after consultation with the Association of Employers and one person appointed after consultation with the employees' trade union to sit in the full tribunal. After hearing the matter before it, any determination by the full tribunal is made by the majority of the members. The Minister of Labor has the power, and he is required under the provisions of the Industrial Relations Act to refer a trade matter or a trade dispute to the tribunal, which he has had difficulty settling or resolving, particularly where time limits established by the Industrial Relations Act. So when it comes to jurisdiction, the tribunal generally hears and determines trade disputes that are referred to it by the Labor Board, or the employee or the employer can go directly to the tribunal. They could register industrial agreements, and they could also adjudicate matters relating to the registration of industrial agreements. So the tribunal can hear, they could receive, they could consider written or oral submissions, arguments, and evidence made by on behalf of an employer or employee trade union representing the employee in the trade dispute. And under the Industrial Relations Act, Section 2, it tells you, for the purposes of the act, a trade dispute is any dispute or difference or apprehended dispute or difference between one or more employers and one or more employees, or between one or more employees and one or more other employees, which is connected with the employment of non-employment of the terms and conditions of employment of any person, and includes a general dispute and a limited dispute. And then it goes to explain what is a general dispute and what is a limited dispute. A general dispute means a trade dispute between an employer and his employees, or any of them, over the creation of new terms or conditions of employment of any such employees. And a limited dispute means a trade dispute between an employer and one or more of his employees over the application to such employee or employees of existing terms or conditions of employment, or the denial of any right applicable to such employee or employees in relation to his or their employment. So an aggrieved applicant or an complainant to the Industrial Tribunal may appear in person or may be represented by counsel. They can be represented by an attorney, by an officer, by a trade union, or by a shop steward. So when you look at the tribunal itself, they have wide powers. First, they could remit a dispute to the parties for further consideration or discussion to reduce or resolve the issue. They could remit the matter back to conciliation meetings with the Labor Board. Because remember, the Labor Board, when it's unable to resolve a matter, can refer it to the Industrial Tribunal. They can make provisional, interim, or final order or award in relation to a trade dispute. They can give directions regarding the hearing or determination of a trade dispute. They can award compensation to an aggrieved to proceedings before the Industrial Tribunal. They can dismiss a matter or part of a trade dispute or other matter brought before it, or refrain from further hearing or determining the matter because it's trivial or frivolous. They can order any person who, in the opinion of the tribunal, may be affected by an order or award, or who the tribunal considers it should be joined as a party. And we're gonna go over a case on that matter today. Hear and adjudicate any question which may arise in relation to a trade dispute in the absence of any party who has been summoned to appear before the tribunal and has failed to do so. They can give directions and do all such things that are necessary or expedient to justify and fairly adjudicate matters before it in a timely manner. They can award interest at a rate that it thinks fit on the whole or part of any order or award of a sum as compensation and damages. They can conduct its proceedings in a manner that it deems appropriate and just in accordance with the Relations Act. The tribunal can issue orders and awards based upon its adjudication of trade and other disputes, but it cannot enforce its own orders and awards. The enforcement or award by a tribunal has to make an application to the Supreme Court, who may enforce an order or award in the same manner and to the same extent effect as the judgment or order of the Supreme Court. So the industrial tribunal procedural rules. So that means that if the complainant wants to bring a matter before the industrial tribunal, or a matter has been referred to the industrial tribunal, there are rules that you have to follow. So first, after a party has filed a trade dispute with the Minister of Labor through the Labor Board, outlining the grounds and particulars of the dispute, the matter is referred by the Minister of Labor to the tribunal. And that's after the Minister of Labor has tried conciliation with the parties. So the party must prepare and file an originating application. And he has to do this in accordance with Form A. So to complete that application, he needs to put his name and address, the name and address of the employer, the relief that he's seeking, and the grounds on which the relief is sought. If in his opinion, any of the affirmation information is not sufficiently particularized in the originating application, the president may request further particulars from the applicant, and he has to submit the information to the secretary within 14 days of the tribunal's notice to furnish such particulars in support the originating application in Form B. If the party fails to comply with the requirement to submit further particulars, the tribunal has the power to strike it out, and they can strike it out in whole or in part. So after the applicant has filed the originating application with the secretary sends the following information to the respondent. So the respondent is the person, let's say if the applicant is Mary Sue, the respondent can be KFC. So in that document, they have to put a copy of the application, a copy of the additional particulars required to be furnished by the applicant, a notice in Form C in the schedule, which includes the information as appropriate to the case about the means and time for entering an appearance and defense, the consequences of failure to do so, and the right to receive a copy of the decision. The respondent then has 7 days within the date of receiving a copy of the originating application to enter an appearance to the proceedings by submitting a notice of appearance in Form D. The secretary then sends a copy of the notice of appearance to the applicant upon receipt of the notice from the respondent. The respondent who intends to resist or wants to defend the application then has to file a defense using Form E. And they have to do this within 14 days. The tribunal has the power under Section 7 of the rules to request that further particulars be submitted by the respondent to the secretary. And that has to be done in Form F. Of the grounds to resist the originating application. The tribunal also has the power under Section 7 to require one party to grant another discovery or inspection of documents, as the Supreme Court may have power to do. It may also appoint the time and place for such discovery or inspection of documents to take place. On application of a party to the proceedings in the prescribed Form G, the tribunal may require the attendance of any person, including a party, as a witness. And if it requires the person to attend as a witness, may also require him to furnish such documents which may relate to the matter before it, inclusive of the time and place for attendance as a witness. And of course, the production of the requested document. The tribunal may also require on application by a party to the proceeding in the prescribed Form H, or of its own motion require a person to furnish a written answer to any question it considers that answer may clarify any issue likely to arise in the determination of the proceedings, and that it would likely assist in the progress of the proceedings for that answer to be available to the tribunal before the hearing. That party can make an application to vary or set aside the requirement under Form I. The secretary will furnish a copy of the requirement for a written answer and the answer to each party to the proceedings. The judge sets the date, the time, and the place of the hearing, and the secretary sends out the notice of hearing in the Form J. The secretary is required to send the notice of hearing to the parties to the proceedings 14 days before the date fixed for the hearing, unless the secretary has agreed a shorter time with the parties. The tribunal has the power and ability to determine any issue relating to entitlement of any party to bring or contest the proceedings on application of a party or of its own motion, but only if the secretary has sent a notice to the parties giving them an opportunity to submit written representations or to make oral arguments before the tribunal. So any hearing by the tribunal is normally open to the public, unless, of course, it's required to be private by the Minister of Labor due to national security. So although the decisions of the tribunal may be made orally at the end of the hearing, it should be recorded in a document signed by the judge. The tribunal should give reasons for its decision in a document signed by the judge, and where an award of compensation is made, the document should contain the amount of compensation, followed either by a table showing how the amount was calculated or a written description of the calculation. The secretary is required to keep a register at the industrial tribunal and place the documents of the tribunal's decision and any document relating to the award of compensation in the register, which should be open for public inspection. And an entry of the decision and or the documents should be sent to the parties to the proceedings and the Minister of Labor. Entries may be omitted from the register where the minister has directed that the tribunal sit in private on grounds of national security, or where evidence has been heard in private and the tribunal so directs. Clerical mistakes or errors could be corrected by a certificate signed by the judge, after which the secretary may make the necessary alterations or corrections in accordance with the certificate, and then send amended copies to each of the party to the proceedings and the Minister of Labor. And the same procedure would be used if there was omitted documents. So if the judge is unable to sign, he may be incapacitated or due to death or just can't sign the certificate correcting the errors and omissions, then the certificate can be signed by any other member of the tribunal. certifying that the judge having carriage of the matter is unable to sign. Then, of course, the tribunal also has other miscellaneous powers. You can fill out a Form K if the applicant at any time gives notice of the withdrawal of the originating application. They want the proceedings dismissed. If both or all the parties agree in writing upon the terms of a decision to be made by the tribunal, they could consider representation in writing, which are being submitted by a party to the secretary. At any stage, they can have an order an order can be made to struck out any originating application, notice of appearance or defense on the grounds that the manner in which the proceedings are being conducted by or on behalf of the applicant, or that the respondent has been scandalous, frivolous, or vexatious. And on application of the respondent or of its own motion, or an originating application to be struck out for want of prosecution. So in any case involving allegations of sexual misconduct, the judge, before a decision is made, either on application by the party made by notice to the secretary or of his own motion, make a restricted reporting order. When a restricted reporting order is made, it must specify in the order the persons who may not be identified, and that the order will remain in force until a decision is made or earlier if it is revoked. The secretary is required to post a notice of the restricted order and its conditions on the notice board of the tribunal and the door of the proceedings relating to the order. The tribunal may extend the time for any procedural action required under the industrial tribunal rules. An extension for time has to be in Form L. And once there's an extension of time, the secretary will send out copies of the notice of extension to all the parties in the proceedings. Now, the tribunal may also give directions on any matter in connection or related to proceedings, and that's done in Form M. The tribunal also has the power to join parties to or dismiss parties from a proceedings on application of any person to the proceedings or of his own motion, once application is made to the secretary to do so. The tribunal may combine proceedings under certain conditions, and they would use Form N. And then I have here, with regard to notices, Rule 18 requires the following procedure. Any notice given under these rules shall be in writing. All notices and documents required by these rules to be presented to the secretary may be presented at the office of the Industrial Tribunal or such other office as may be notified by the secretary to the parties. All notices and documents required or authorized by these rules to be sent or given to any person hereinafter mentioned may be sent by post or delivered to or at, in the case of a notice or document directed to a party, the address specified in his originating application, or notice of appearance to which notices and documents are to be sent, or in a notice under paragraph 4, or if no such address has been specified, or if a notice sent to an address has been returned to any other known address or place of business in the Bahamas. And then it goes on to speak about the body corporate and its address. Any comments?
That was a mouthful, my comment.
I was just gonna say, other than the fact that was a lot.
Yeah, but it's a long process. It's a long process. Okay, so let's see if we could put it in some practical sense. If you have a pen handy, sometimes it's good to write the dates. And I will send these to you all tomorrow. These two cases. All right, so this case is a Court of Appeal case. So remember, the judicature of the Bahamas, magistrate. Yes, lower court, magistrate, Supreme Court, Court of Appeal, and Privy Council. So this is Court of Appeal. This matter is Ethos Holdings Limited. They are appealing. And the respondents are Jessica Grant, Wendy's Limited, Ethos Holding Limited, and Nomolus Limited. Everybody knows who Ethos Holdings Limited is, right?
Is
No,
that
ma'am.
Wendy's? That's not Wendy's?
Yes, it is Wendy's.
Yeah, Wendy's,
Oh.
right?
Yes. Okay. So the appellant is Ethos and the respondent is Jessica Grant. So write those down because most of the time they speak about just respondent and appellant, so you don't get confused. So the first respondent is Jessica. So Jessica worked at Wendy's restaurant in Freeport, Grand Bahama. She was dismissed by Ethos Holdings Limited and given a check in the amount of $2,400. She filed a dispute against the appellant, Ethos. The dispute was referred by the Minister of Labor to the Industrial Tribunal. In the report of the trade dispute, the first respondent named Wendy's Limited as the company against whom she was making her complaint. A defense was filed by Ethos Holding Limited, and Ethos Holding admitted that it was the employer of Jessica and that Ethos Holdings had terminated her employment. Counsel for the first respondent applied under Rule 16 of the Industrial Relations Rules for Ethos Holdings Limited to be joined as a party to the action, as it acknowledged that it was the employer who terminated the first respondent. The vice president made an order for Ethos Holdings Limited to be joined as a party to the proceedings. Now remember what's one of the powers I said that the Industrial Tribunal has. What's one of the powers?
It is able to join.
Yes, it can
Yeah,
join.
it is able to join, yeah.
So
Okay,
at the end of the hearing, before the vice president of the tribunal, an award was made in favor of Jessica. Ethos now appeals against that decision. So let's see what the judgment was delivered by the Honorable Sir Michael Barnett. Let's see what he says in his judgment. He said, this is an appeal by Ethos Holdings against an award by the Industrial Tribunal for the wrongful/unfair dismissal of its employee, Jessica Grant. The award granted the 15th of December, 2021 was for the sum of $19,625. Remember how much I said Ethos gave her?
25? You said
24.
2,500?
2,400.
Yeah. So the sum represented an award for wrongful dismissal. The appeal is not for the award for wrongful dismissal. The appeal is not that the award for wrongful dismissal should not have been made. The appeal is based on the submission that as the originating application was brought against Wendy's Limited, there was no basis for making an award against Ethos Holdings Limited. You see how they get tricky?
Yeah,
Yeah,
because
yeah.
ASOS is the governing body for Wendy's, right?
Yes,
Mhm.
yes,
But it was
okay.
filed under
Filed
Wendy's. you said.
directly to Wendy's.
To
Yeah,
Wendy's,
understood.
right.
Mhm.
Mhm.
Okay, so hold on. I'm glad we are listening attentively.
You mean
So-
another twist to this? We can't take any more twists.
The basis of the appeal was summed up in the following exchange at the hearing. The president, Mr. Ferguson, let us cut to the chase. Your appeal in this matter on behalf of Ethos Limited is that Ethos Limited was not a party to the originating application and that the tribunal did not have the power to join Ethos Limited as a party to the proceedings, and therefore any judgment against Ethos Limited is null and void. That is your case, is it not? Mr. Ferguson, the lawyer, yes. The president, anything else other than that? Mr. Ferguson said, that is in effect our case. The president said, okay, anything else? Mr. Ferguson said, no, my lord. The president said, thank you. So in our judgment, this appeal is wholly without merit. This is Michael Barnett speaking now. It is correct that the report of the trade dispute brought by Ms. Grant named Wendy's Limited as the company against whom the complaint was made. However, at the conciliation meetings at the Department of Labor, remember that's the very first step,
Right.
the respondents Wendy's Limited was represented by the human resources manager of Atos Holding Limited.
Wow.
It is also correct that the referral by the minister was the referral of a dispute between Ms. Grant and Wendy's Limited. There is also no dispute that the dispute arose out of the termination of Ms. Grant's employment at Wendy's restaurant in Freeport, Grand Bahama. The problem was that Ms. Grant's employer was Atos Holding Limited and not Wendy's Limited. The termination letter made that clear. It said, quote, termination with cause, gross misconduct. Dear Ms. Grant, effective immediately, Atos Holdings Limited, in bracket, Wendy's Restaurant, Bahamas, close bracket, is terminating your employment with cause due to a breach of company policy number 12. Failure to follow company cash management or cash control policies. And number 9, dishonesty of any kind, including falsification of any document, card, papers, timesheet, sales slip, or other document, and or failure to process all sales in strict accordance with company policy and or providing any type of false information to management. Please find enclosed a check in the amount of $2,400, which represents your final pay. Please return all company property immediately, including uniforms, to our administrative office. We wish you all the best in your future endeavors, end quote. The problem was identified immediately. In the appearance filed to the originating application, the appearance was not made by Wendy's Limited. The appearance was entered by Atos Holdings Limited. The defense to the originating application was filed by Atos Holding Limited and not by Wendy's Limited. In its defense, Atos Holding admitted that it was the employer of Ms. Grant and that she was terminated by them. It said in defense, quote, during the period January 20th to July 2020, January 2020 to July 2020, an investigation was conducted into Jessica's cash management and related system transactions. 1, the audit investigation findings reveal a substantial number of void were processed by Jessica. The timing, clearing, and volume of these transactions construes a gross misconduct by failure to conduct job duties satisfactorily and conducting inappropriate business and administrative practices not in line with standard company policies and procedures. 2, the respondent terminated the applicant on September the 2nd, 2020 for breach of company policy number 12, failure to follow company cash management or cash control policies. And number 19, dishonesty of any kind, including falsification of any document, card, papers, timesheet, sales slip, or other documents, and or failure to process all sales in strict accordance with company policies and or providing any type of false information to management, end quote. Recognizing that Atos Holding Limited ought to have been made a party to the action, as it acknowledged that it was the employer who terminated Ms. Grant, counsel for Ms. Grant applied under Rule 16 of the Industrial Relations Tribunal Procedure Rules for Atos Holdings Limited to be joined as a party. And then it says Rule 16 provides the tribunal may at any time on the application of any persons made by notice to the secretary in Form M in schedule or of his own motion, direct any person whom any relief is sought to be joined as a party. And then put it the other two clauses. This rule has been in Industrial Relation Tribunal rules since 1997. By a ruling made on the 20th of August, 2021, the Vice President ordered that Atos be joined as a party to the proceedings. At that time, there was no appeal against the order joining Atos as a party. The hearing continued. According to the tribunal rulings, Atos Holdings Limited, quote, failed to appear at the trial and to adduce evidence to prove that it had conducted a reasonable investigation into the applicant's alleged misconduct, or that no investigation was warranted in all the circumstances of the case, end quote. The tribunal made an award in favor of Ms. Grant. Atos now appeals that award. In our judgment, there can be no possible complaint to the order joining Atos Holding Limited as a party to the action. Atos Holding Limited was the employer. It admitted that it was the employer and stated its reasons for terminating Ms. Grant. The power to join Atos cannot be challenged as it is clearly provided for in the rules. It was a proper exercise of the tribunal's power to join Atos. Counsel's reliance on this court's decision in Island Hotel Company Limited versus John Fox is misplaced. There was no issue of joining another party to the proceedings to determine the claim being brought by an employee in that case. This is not a case where an issue is being considered by the tribunal that was not referred by the minister. The referral by the minister was a trade dispute for both wrongful and unfair dismissal arising out of the termination of Ms. Grant's employment by her employer. There is no dispute that Atos Holding Limited was her employer and was the entity that terminated her employment. Counsel for Atos suggests that Rule 16 is ultra vires the Industrial Relations Act, as it purports to allow a claim to be brought against a person who was not a party to the trade dispute and who had no opportunity to conciliate the dispute before the minister's referral. So Barnett then quotes Section 59 of the Industrial Relations Act, which provides that in addition to the powers conferred on it under the foregoing provisions of this act, the tribunal may proceed to hear and determine any matter, any question arising in connection with the dispute in the absence of any party who has been duly summoned to appear before the tribunal and has failed to do so. So it says in the exercise of its powers, the tribunal must be mindful of Section 57 of the Industrial Relations Act. And that section provides that in the hearing and determination of any matter before it, the tribunal shall, so far as it appears to be up to it appropriate, seek to avoid formality in its proceedings. It shall not be bound by any written law or rule of law relating to the admissibility of evidence in proceedings before courts. It shall make such inquiries of persons appearing before it and witnesses as it considers appropriate. Because remember now, the Industrial Tribunal is a quasi body. All that formality is not required. So Sir Michael Barnett said, in my view, Rule 16 is not ultra vires the Industrial Relations Act. Atos Holding was properly joined. It is not uncommon for courts to permit the joinder of a person as a party to an action where it is discovered that the person being joined is a necessary and proper party to a dispute. The issue was still wrongful and unfair dismissal. Moreover, in this particular case, Atos Holdings Limited actually participated in the conciliation meetings and can assert no prejudice by being joined as a party to the action. Atos, having been properly joined, chose not to adduce any evidence at the hearing. It cannot complain about the tribunal accepting Ms. Grant's uncontroverted evidence and finding in her favor. Appeal is dismissed. Any comments? We have some HR professionals now. So what you all think?
Yeah, I mean, it's so, she was awarded this 19, you said?
19,000. I'll look and see if I can find the industrial tribunal.
So how did they arrive at the 19? Is that what she, what
No,
determines?
and the tribunal will do their own calculations.
Okay,
I'll
okay,
look and I have that one. If I have that one, I'll send that along with this one.
okay,
So you can see how they did the calculations.
okay,
That's not a problem.
okay.
Now, the next one is a case of Ricardo Hart and Odyssey Aviation Bahamas. You know where that is, right?
Yes.
Okay, so this is another matter of unfair dismissal. It was referred to industrial tribunal by the Minister of Labor under his certificate. And the matter was filed in the tribunal by an originating application. The claim is brought by Ricardo Hart against his former employer, Odyssey Aviation Bahamas, for compensation as he alleges that he was unfairly targeted for dismissal. So Ricardo was employed with Odyssey from the 27th of July, 2010, until the time of his summary dismissal on the 6th of May, 2020. So that's roughly 10 years. He was first hired as an assistant manager at the General Center of Odyssey. He was eventually promoted to safety and security manager, and he earned $4,307.70 per month. So Mr. Hart's dismissal came about as a result of an incident which occurred when 3 employees of Odyssey, Mr. Hart himself, Thaddeus Simonet, and Louis Joseph, attempted to tow a G450 aircraft into the western hangar at the Lynden Pindling International Airport. The aircraft was damaged when its tail struck a wall beam in the hangar. Odyssey's evidence was that the company eventually had to pay some $27,000 to repair the damage to the aircraft. The applicant's main contention in support of his claim is that the accident involving the aircraft occurred on the premises of Odyssey, which involved 3 employees. He argued that he was the only one of the 3 who was summarily dismissed by reason of the accident. So during the course of the trial, he also argued that his dismissal was unfair because Odyssey did not have adequate safeguards in place to prevent the accident from occurring. Specifically, he contended that a 3rd person should have been included to watch the tail of the aircraft. He also contends that the investigation was unfair because he was never called in and asked questions during the process.
Excuse me, Ms. Archer, but you did say, I just want to clear that he is the safety and security manager? Did you say that was his title?
Where is it? He was eventually promoted to safety and security manager. Yeah.
So he was the manager of safety and security. I just wanted to make sure that that was his responsibility. Okay, thank you. Thank you.
Okay. So the respondent entered their defense, by which it stated that Mr. Hart was not unfairly dismissed as alleged or at all. Odyssey contended that Mr. Hart was terminated for gross negligence and incompetence because he failed to watch the aircraft as he was tasked, and he failed to warn his co-workers of the position of the tail of an aircraft as it was being placed into the hangar. Odyssey stated that Mr. Hart was distracted or not paying attention, and this led to the collision with and damage of the tail of the aircraft by a wall beam. During the course of the trial, Odyssey also submitted that its procedure in towing the aircraft was in compliance with minimal industry standards and substantially met the standards which Mr. Hart contended ought to have been in place for the towing of the aircraft. So factual matrix. In relation to the events which occurred on the 1st of May, 2020, and subsequently, the tribunal heard the direct evidence of Mr. Hart and 3 of Odyssey's witnesses. Thaddeus Simonet, you remember now, Mr. Hart said when the incident occurred, it was him, Thaddeus
Seminole and Joseph.
Smith, right?
Mhm,
So the tribunal heard the direct evidence of Mr. Hart and
Mhm.
3 of Odyssey's witnesses, Thaddeus Smith, Louis Joseph, and Anissa Musgrove. Anissa Musgrove was the manager of HR. The tribunal also reviewed the contemporaneous incident reports given by Mr. Simonet, Mr. Hart, the applicant, and Mr. Joseph, and the witness statements of all witnesses who appeared to give evidence at the trial. The tribunal considered all documents filed by the parties. The tribunal accepts the facts as follows. 1. On Friday, the 1st, May 20th, Mr. Simonet requested that Mr. Hart and Mr. Joseph assist him in towing the aircraft into the Western Hangar. Mr. Simonet drove the towing vehicle and was positioned in front of the nose of the aircraft. Mr. Hart was given the task by Mr. Simonet of left wing walker, and Mr. Joseph was assigned by Mr. Simonet to be right wing walker. The personnel involved were formally trained in the job of wing walking and towing procedures. Both wing walkers were to walk alongside the aircraft as it was being towed into the hangar, and in the process to watch parts of the aircraft which were on their side of the aircraft. They were also supposed to communicate with Mr. Simonet, who did not have a view or full view of the wings and tail of the aircraft as it entered the hangar. Mr. Hart, during the trial, stated that Mr. Simonet was in charge of the operation and ultimately responsible for managing the towing of the aircraft. Now, I don't say that could be possible if he can't see.
Mm.
So, 3, there were no formal written towing procedures at Odyssey, but Odyssey saw that its personnel involved in such procedures were trained. Mr. Simonet also testified that from the training received, he extracted procedures for Odyssey's personnel to follow and posted the same in the line service area of Odyssey's premises. 4, Mr. Hart attended formal training in 2019 for towing procedures, and when he returned, Odyssey formed a safety and security committee to draw up a formalized set of safety policies and procedures. However, it was still a work in progress by the time of the incident, which led to the dismissal of Mr. Hart. Mr. Hart testified that the policy current at Odyssey was that tow truck drivers would be assisted by 1 wing walker for the towing of an aircraft. However, Mr. Hart stated that industry standard dictated that 3 wing walkers should be used in the hangar.
Mm.
He then referred to an article he accessed from the internet.
Mhm.
The standard set out in the article called for using a minimum of 2 wing walkers for hangar stacking, and 3 were recommended for night operations. The towing of the aircraft on May 1st, 2020 was a daytime operation. The tribunal accepts that in terms of the number of wing walkers used, Mr. Simonet, in utilizing Mr. Hart and Mr. Joseph, complied with the standards set out in Mr. Hart's article. As well, the tribunal notes that Mr. Hart eventually admitted in cross-examination that Odyssey's standards comply with minimum industry standard for towing an aircraft. Further, the tribunal accepts that not all of the standards contained in the article produced by Mr. Hart would have applied so as to prevent the type of damage in the aircraft sustained. He probably didn't read the article before he submitted it.
Mm.
On the 1st of May, 2020, Mr. Simonet towed the aircraft while Mr. Joseph Wing walked with him up to the door of the hangar. They met Mr. Hart at the hangar. However, just prior to approaching the door of the hangar, Mr. Joseph could see into the open door of the hangar that Mr. Hart was engaged in positioning the mats, which were intended to be placed under the wheels of the aircraft. The aircraft had been in the hangar earlier that morning and was brought out. This towing exercise was therefore to bring about the re-entry of the aircraft into the hangar. Because the aircraft had already been parked in the hangar, the mats were already properly positioned, according to Mr. Joseph. He stated that there was no need for Mr. Hart to move the mats again, but he saw Mr. Hart doing it.
Mm.
Tribunal accepts Mr. Joseph's testimony that the mats were in place when the aircraft was first moved out of the hangar, and that there was no need to move them again, but Mr. Hart moved them again. 7, the floor of the hangar was covered with an epoxy finish, and the mats were put there to prevent the floor from getting scuffed or dirtied by the wheels of aircrafts which were parked there. It is important to protect the floor in this way. It was also vital to ensure that towing of aircrafts was done safely so that such aircrafts would not be damaged. 8, when Mr. Simonet and Mr. Joseph brought the aircraft to the door of the hangar, they met Mr. Hart there. Mr. Simonet asked each wing walker to watch their areas of the aircraft, with Mr. Hart assigned to the left and Mr. Joseph assigned to the right. Another aircraft was already parked in the hangar. He referred to that as the parked aircraft. The aircraft was moved into the hangar by Mr. Simonet, and it cleared the nose of the parked aircraft. Mr. Simonet then stopped. Mr. Hart ran to the mats and moved them again. Mr. Simonet then assigned Mr. Hart to watch the tail of the aircraft and for Mr. Joseph to continue to watch the left wing. As he moved the aircraft, Mr. Simonet asked for feedback from Mr. Hart and Mr. Joseph so that he could make any adjustments required to be made to his driving and positioning of the aircraft. Mr. Joseph communicated that his end was clear. Mr. Hart said nothing. Mr. Joseph asked Mr. Simonet to stop. Mr. Joseph told Mr. Hart not to worry about the mats, which the applicant was again adjusting, and to watch the tail of the aircraft. Mr. Simonet also told Mr. Hart not to adjust the mats, but to watch the tail of the aircraft. 10. Mr. Simonet asked Mr. Hart if he could proceed, and Mr. Hart answered in the affirmative. As the aircraft was moved further into the hangar, the tail of the aircraft collided with a wall beam. Mr. Joseph told Mr. Simonet to stop and informed him of the collision with the tail. Mr. Simonet stopped the aircraft towing, got out of the vehicle, and went to the rear of the aircraft. He asked Mr. Hart what happened. Mr. Hart said nothing. Mr. Simonet was upset and told Mr. Hart, "You don't need to be here." Mr. Simonet then called the president of Odyssey, Mr. Kelly, to report the incident. The dent in the aircraft was temporarily straightened out and the aircraft was taken for an assessment. Mr. Hart was directed to the Human Resource Department, where he gave a handwritten account of what occurred in the presence of Anissa Musgrove, the Human Resource Manager. Mr. Hart took responsibility for the accident and told Ms. Musgrove that he was willing to pay for the damages. So Odyssey launched an investigation. Mr. Hart's first handwritten report, he appended his name at the top of the page with another basic information and then stated, quote, "On Friday, the 1st of May, 2020, I was wing walking G450 and 904 TS along with Louis and Thaddeus was driving the tug. I was watching the tail of the aircraft when it collided with the beam of the hangar. I accept full responsibility for not alerting Thaddeus to this beam sooner. The pilots were notified of the incident, time of incident, 12:15. Some days later, Mr. Hart produced a typed account of the incident and resiled from taking full responsibility for the accident. He stated that he was assigned to wing walk, but he was also lining up the mats for arrival of the aircraft's main gears. He said he was busy between the area of the aircraft's tail, the wingtip, and adjusting the mats. He then wrote, "In my opinion, there should have been a third wing walker in place to be directly focused on watching the tail solely. I acknowledge my role in this incident, and I'm of the opinion that this incident is collectively responsible by all persons involved, along with the lack of a third wing walker."
Okay, so he changed his talk then.
What is so funny is that they keep saying he was moving the mat. Why was he moving the mat?
Moving the math, yeah, yeah. But I have a question. So the reporting, like how it's written in the the reporting that you gave, is that done by someone on the tribunal? Because you said that several persons can sit to hear these cases, right? Or is it someone, like how it's put together, is that done by someone on the tribunal, or that's done by the lawyers or whomever?
No, this was written by the vice president, Simone Fitzgerald.
And that's a part of the vice president of the tribunal. So
Uh-huh.
this is information that she gathered from the various witnesses from
Yeah.
Odyssey.
Uh-huh.
Okay. Okay.
And the documents, the exhibits that they would attach to the documents. So let's
Okay.
say if you file originating application stating what happened, then he would
Right.
attach
Right.
his documents. Odyssey would attach their supporting documents.
Okay. But his reporting would be based on what they submitted, though.
Yes.
Yeah. Okay.
So he said he take full responsibility. Then he came back
Right.
and no.
Then he said no. Right.
Right. So Mr.
Okay.
Simonet also produced a handwritten report of the incident.
Right.
And
Okay.
okay, in his report, he documented that he and Mr. Joseph met Mr. Hart moving the mats around.
Right. Okay.
He
Okay.
assigned them their wing walking jobs. He
Right.
stated, this is what he wrote in his report. As I was pushing the aircraft into the hangar, I asked Ricardo to watch the right wing passing the nose on HBIVJ.
Mm-hmm.
N904TS left wing passed the nose of HB1VJ and all was clear. I came to a complete stop with N904TS. Ricardo then proceeded to move the mats again.
Mm-hmm.
At the time, the mats had to be realigned. I then asked Ricardo to watch the tail and Lewis to watch the right wing. The left wing was clear. I then proceeded to push the aircraft back slowly. As I was pushing back, I asked Louis and Ricardo to talk to me. Louis shouted, "My end clear." At this point, Ricardo still was not saying anything. He then ran to the mats again, trying to align them. Both Louis and I said to him, "Don't worry about those mats now, just watch the tail." I then proceeded to push back on N904TS. Within a few moments, Louis said to me, "Stop, Thaddeus, the tail hit." So in cross-examination, Mr. Hart admitted he did not tell Mr. Simonet he felt that a third wing walker was necessary on the 1st of May 2020.
Mm-hmm.
He also admitted that he was not solely focused on the tail of the aircraft, which approached the wall, but was also looking at the mats. He admitted that he was told to watch the tail and not to worry about the mats. He clearly did not obey this directive from the person responsible for managing the operation, that is Mr. Simonet. He also ignored the similar advice given him by his co-wing walker, Mr. Joseph. The applicant was suspended with pay pending the investigation, which involves Mr. Joseph and Mr. Simonet, who gave verbal and written reports. Parts of the investigation were conducted by Mr. Holoesco, the general manager, Mr. Sherwin Penn, and Mr. Nathaniel Raphael of the Respondent Safety and Security Committee. Ms. Musgrove stated that she was surprised to receive a second incident report from Mr. Hart after he had already submitted his same-day report of the incident. Both reports were considered by the respondent, and in a second meeting, which took place on the 6th of May 2020, Mr. Hart was given an opportunity to explain his position. The meeting included Mr. Rappel, Mr. Anthony Hinsey, a member of Odyssey's executive team, Ms. Musgrove, and Mr. Hart. Mr. Hart stated that he had nothing further to say. Mr. Hinsey then explained that the respondent felt, as a result of his investigation, that the accident occurred because he was not paying attention and he was not communicating with Mr. Simonet.
Mm-hmm.
Hinsey further explained to the applicant that the respondent decided they could not continue to employ a security and safety manager who did not take responsibility for his actions and sought to place the blame on others. Mr. Hinsey told Mr. Hart that if he felt a third wing walker was necessary, he should have suggested it. As a result of his actions, the company had to expend money to fix the damaged aircraft. The applicant was therefore summarily dismissed for gross negligence and incompetence. He was given a letter from the general manager, Mr. Holoesco, which stated these reasons for his dismissal, and he was paid $5,520.77 as pay for work performed and vacation, less national insurance and other deductions. This was the process afforded Mr. Hart before his summary dismissal. After his summary dismissal, a report was finalized on the 18th of May 2020, in which Mr. Penn and Mr. Rappel concluded that, quote, at the crew request, the aircraft was being towed for parking into the western hangar by a team of 3 persons. Mr. Thaddeus Simonet was driving the tug, while Mr. Ricardo Hart and Mr. Louis Joseph acted as wing walkers respectively on the left and right side, on the left and right wings. As the aircraft was being pushed into parking position inside the hangar, the tug driver requested feedback from the wings walkers to make necessary adjustments to his driving and aim. Mr. Hart did not respond promptly as he engaged in tidying up mat markers while the aircraft was being pushed closer to the hangar walls. The lack of feedback from Mr. Hart resulted in the aircraft tail coming into contact with a wall beam. The tip of the tail stabilizer was dented. Described the specific ramp system failure, absence of communication from the wing walker at the aircraft tail interrupted the continuous flow of information the tug driver needed to adjust his driving. The lack of prompt response from Mr. Hart to Mr. Simonet's request for obstacle distance information resulted in inaccurate feedback being passed on as the tail wing walker was not fully focused on the aircraft being maneuvered closer to the hangar walls, end quote. The tribunal accepts that Mr. Hart's decision to divide his attention between the aircraft mats and the aircraft was a major contributor to his, tail of the aircraft. Further, his failure to tell or signal to Mr. Simonet to stop before the aircraft's tail hits the wall beam, a responsibility which was solely assigned to him, was the direct cause of the accident. If he wanted to have time to fix the mats, he ought to have asked Mr. Simonet to stop to allow him to do so. The tribunal is satisfied that the applicant's failings caused the accident. Further, his earlier movement of the mats caused the requirement for further repositioning of the mats when the aircraft was again brought to the hangar. So the law, this is the law and the disposition. It is imperative to note that in this case, the tribunal is not asked to determine whether sections 31 to 33 of the Employment Act, which deal with justification for a summary dismissal, was contravened by Order C. This is not a claim for wrongful summary dismissal. Rather, it is a claim in which the fairness of the dismissal is being challenged. This claim is therefore governed by sections 34 and 35 of the Employment Act. Section 34 states, every employee shall have the right not to be unfairly dismissed as provided in sections 35 to 40 by his employer. Section 35 says, subject to section 36 to 40, for the purposes of this part, the question whether the dismissal of the employee was fair or unfair shall be determined in accordance with the substantial merits of the case. So in the case of Cartwright versus US Airways, the Court of Appeal considered what is meant by the substantial merits of the case and the manner in which courts are to go about fulfilling the requirements of section 35. In that case, the court stated, what does the phrase, the substantial merits of the case mean? The question is whether what the employer thought had happened in the circumstances in which the employer thought the conduct to have occurred was or was not sufficient to justify the employer's actions so as to be held not unfair within section 98, subsection 4. At paragraph 23, Judge Langstaff stated that the statutory question is answered by a factual inquiry. Thus, it was incumbent upon Winder J to look at the case in the round at all of the circumstances of the case and arrive at a decision based on the substantial merits of the case. This he did do. So unfair dismissal claims can take manifold forms. There are some reasons for dismissal deemed by statute to be unfair. These reasons are provided in sections 36 through 38 and section 40 of the Employment Act and are irrelevant to this matter. All other matters of unfairness in a dismissal are covered by the virtue of section 35. And you can see that in the judgment of the Court of Appeal in BMP Limited, Crystal Palace Casino versus Yvette Ferguson. The tribunal considers that the question in the instant case is whether, after conducting a factual inquiry into the substantial merits of the case, there is anything which occurred in the procedure afforded Mr. Hart during the investigation and or termination process which made his dismissal unfair. The applicant alleges unfairness primarily on the basis of three arguments. He states that he was not asked questions during the investigation. As well, he has complained that he was discriminated against or singled out for punishment when his view was that Mr. Simonet and Mr. Joseph should have been punished also. He argues that Odyssey ought to have used a third wing walker in the operation of moving the aircraft. So I think he goes on and give you some cases. But let me go to where he's going to. He says, the tribunal is of the view that the employer conducted this inquiry and gave Mr. Hart a chance to state his case. Mr. Hart was well aware the accident of the 1st of May 2020 was being investigated, and specifically whether his actions caused the damage. He met with Ms. Musgrove and gave her verbal and handwritten representations concerning the incident. He was able some days later to give a second account. Both accounts were taken into consideration. The applicant was then afforded another opportunity to state his position on the 6th of May 2020, which he declined. The parties seemed for the most part to agree the facts concerning the accident. All accounts were similar, and Mr. Hart admitted at the trial that he was not watching the tail alone, as he was asked to do by the manager in charge of the towing operation. He instead decided to divide his attention at a crucial stage of the towing of the aircraft. The tribunal does not therefore hold the view that Mr. Joseph or Mr. Simonet should have been dismissed or punished along with Mr. Hart. There is no satisfactory support for his claim of discrimination. Having considered the guidelines for towing procedures produced by Mr. Hart, the tribunal is satisfied Odyssey's procedure on the day of the towing of the aircraft was within minimal requirements. Further, Mr. Hart, as safety and security manager, did not raise a red flag concerning whether there were adequate wing walkers. Additionally, in the tribunal's view, it was not for lack of an extra wing walker that the accident occurred, but rather because Mr. Hart ignored specific instructions and did not communicate to stop the towing of the aircraft so that he could assess the distance of the tail to which the wall beam of the hangar, or so that he could fix mats if the same was necessary. Or alternatively, so that he could ask Mr. Joseph to fix the mats while he watched the tail of the aircraft. Again, the tribunal is not asked to find whether the dismissal was wrongful, that is, whether it was justified as a result of the employer's honest and reasonable belief Mr. Hart committed gross negligence or was incompetent. The sole remit of the tribunal is to gauge the fairness of the applicant's dismissal on the basis of his contentions. At the end of the day, the tribunal could find no circumstance in this case sufficient to support the claim Mr. Hart has been unfairly dismissed. The tribunal is satisfied that the process afforded Mr. Hart an investigation leading up to his eventual dismissal was reasonable and fair. And in the circumstances, the tribunal orders that the originating application be dismissed. Dated the 3rd of January, 2023 by Vice President Simone Frisch-Charles. Any comments?
And you did say that these reports are for public viewing. Are they for public viewing or?
Yeah, they are.
Yeah, okay.
They are. I'll see if I can find Jessica versus Atos at the
Okay.
tribunal. I'll see if I
Okay.
can. I have the other two. So I'll look for that one and then I'll send you those. And then for next week, I'll probably send, let me see. I'll see if I can find some that are not too difficult. Because most of them, some of them are very long. So I'll try to find some shorter ones for next class.
Okay.
And I'll do some assignments. So in my email, I'll tell you who's presenting what. So you can get a feel of how the court applies the Employment Act and the rules.
Okay.
Okay. So these
Mhm.
ones we've already done, but I'll assign some to you all. So you should have some fun.
Mhm.
Yeah, the court, especially when it goes through these procedures and it listens to the evidence that's given and it looks to
Right.
see what the employer actually, when they did the investigation, if they carried it out properly.
Right. Right.
Yeah. So I'll look for some cases on that one too. Any other comments?
I think that case is very clear. Mr. Hart actually admitted that he was in the wrong in his initial statements. I don't even understand why he would go
I
to
think
the
he was, yeah, I think he was
You know what?
advised, you just get wrong information from people. So he
But
may have been advised.
yeah, but
I think when he realized the damage was $27,000 and he couldn't
Exactly.
underwrite the cost of it.
Yeah.
exactly. When he realized that it cost 27,000,
27,000. That's where
Yeah.
it took a turn. Yes, for sure.
yeah, because he thought he probably could have just bombed that out and that was it. But when he hit 27,000, very quick.
Mhm.
But he should have realized that being the safety manager, he had a
Right.
responsibility.
Stability. Yeah,
That
definitely.
was his responsibility, his area.
Yeah, but I don't
That's not
understand.
his.
Why was he fiddling with the maths?
Hmm.
What was the significance with the maths?
Yeah.
It's an aviation thing we wouldn't understand.
Yeah, but you notice he never gave an explanation as to why he
Explanation.
moving the
Yeah.
math.
Yeah.
There must,
Yeah.
I mean, I don't know. There must
Yeah.
have been some rationalization behind it, but nonetheless, to your point, I forgot who was speaking. It was pretty clear when he initially admitted and said he'd underwrite the cost for the damages. So
Yeah, tell you heard it was 20,000, then he changed his talk quick.
absolutely.
Yeah, but I
Absolutely.
mean, he admitted he was playing with the maths. Why was he playing with?
Yeah, what my view,
Archie, you keep
my-
asking us the question we
Just-
don't know about the math.
well, I just want to put a little twist to it, and it may be because of his safety measures. He's more interested in the mat because he doesn't really know about the towing procedures. So he's more familiar with I think it was the floor you said with epoxy has to be on it. And so
Yep.
that's what he was more concerned about than as far as the rules of watching the wing. And so maybe that's what the misjudgment was. Just a thought.
That's a good point. He should have actually stated that. He should have stated that though.
Yeah.
You don't think he should have admitted to his boss that he didn't?
No, I think he's just trying to get some other people to be part of the blame. That's all. Misguided.
Mm. Yeah, so we'll see what happened after he made the first admission. He gone and asked some people and then come up with that funny thing.
Yeah, that's what I'm thinking. I'm thinking that he was wrongly advised. That's what I'm thinking. But he was told to revert from,
Mm-hmm.
yeah, that's what I'm thinking.
Poor soul. Awesome. All right, I'm gonna find some more and send it to you all in a sign, so you'll see my email tomorrow.
Okay,
Okay? So read chapter 3, 1 and 2 if you haven't. Chapter 3, and then I'm gonna look for some cases tonight to send to you all.
so the, and so all that you'd read, earlier, then it's pretty much with the drafting, I guess we kind of figure out like with the drafting of the appeals and all that stuff in the various categories that you had outlined earlier in writing, in the setting up the tribunal and all that stuff.
Yeah, that was
Yeah.
just the historical part of when the
Right.
tribunal started, following what was done in the UK, the
Mhm.
laws that relate to this whole procedure when you go to the tribunal with your
Right.
matter, the
Right.
forms that you have to complete. And then
Right.
chapter 1 was just about just the laws, where our laws came from.
Right, okay.
Yeah.
And then how things are set up and the witness and I guess all that stuff
Yeah.
too. Yeah, the do's and don'ts.
Mm-hmm.
Okay,
Yeah. So that's what the introduction is all about. But then we move from that now. When we come next week, we're going to talk about the employee, employer, the contract itself.
okay,
So the cases
Okay.
we discussed tonight is it for those who don't know about employment law, it may be difficult, but a lot of you are familiar with employment. So I'm showing you how, just looking at the rules and how they are in
Mhm.
place, how it is in practice.
Mm-hmm.
Yeah. And then you'll see when you read the cases how the process that the
Mhm.
employer puts in when there is an incident is critical when you go before the tribunal.
Right. And to have all the
You have
information.
to do it right. Yeah, you
Yeah.
have to do it right.
Mm-hmm. Mm-hmm. If you want it to work in your favor, I guess.
Exactly.
Mm-hmm. Mm-hmm.
So you'll see when I give you the cases and we go through them, and then you'll see the mistakes that people make. You'll also
Right.
see sometimes where people get the wrong advice,
Right.
you know, but
Right.
you'll begin to see. And you'll be able
And
to.
I think too that you have some employees that kind of figure that they have certain rights in certain jurisdictions, to certain things, and you come to find out that no, you really don't, you know? Yeah, yeah, yeah.
So I'll try and find some that are interesting.
Yeah. Mhm.
I'll try and
Okay.
I'll and then you could also make note of the attorneys that represent either the plaintiff or the defendant.
Okay.
Yeah.
Is that's of relevance too, or?
Sometimes it is
Huh.
when you look at the outcome and you look at what was presented,
Mm-hmm.
you say, oh my God, they were ill advised.
Mm.
Yeah.
Yeah. Okay.
You can see sometimes where they were ill advised.
Mm. Yeah.
Okay. Find
Okay.
some cases. Let me see. We have 1, 2, 3, 4, 5, 6, 7, 8. I don't know if we'll have time to do 8. That may be too many. But I can still assign 8. And then when we meet again after midterm,
Mm-hmm.
it goes through them. We'll see how many we could go through next class.
Okay.
Okay?
Okay.
All right. So look out for your email. I'll let Ms. Dean send it.
Okay.
Okay?
Great.
All right. So
Yeah.
have a good evening.
Okay. All right. Thank you.
Good evening.
Okay.
Have a
Good
evening.
night.
Good night. Okay. Bye-bye.